Hi guys, and welcome to another episode of Attorney Javier's Law Lectures for Students. For today's episode, I'll be discussing the concept of liquidation of insolvent juridical debtors as provided under Republic Act number 10142, otherwise known as the Financial Rehabilitation and Insolvency Act, or FRIA for short. Take note that today's discussion on liquidation will focus on insolvent juridical debtors, meaning partnerships and corporations, and we will also include sole proprietorships as well. Thus, natural or actual persons, these are not covered by today's discussion, especially since I have already discussed the remedies of insolvent individual debtors in the previous episode on suspension of payments and liquidation of individual debtors, which you may watch instead. Also, while I may give an overview of some procedural rules here, I will not be discussing procedure in detail, as the focus will remain on the discussion of substantive aspects of the law on liquidation of juridical debtors. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. Now let's begin. So for today, we'll be discussing the liquidation of juridical debtors or juridical persons. And when we say juridical persons, the law defines them as beings with legal existence, susceptible or capable of having rights and obligations, or of being the subject of juridical relations. Specifically, juridical persons are not natural or actual people, but rather they are artificial beings treated by law as having a separate individual personality from other people or entities. The most common examples are partnerships and corporations, which are treated as separate persons or entities from the directors, officers, stockholders, employees, or partners that may compose the partnership or corporation. To illustrate, let's say we have XYZ firm, which is a partnership made up of partners X, Y, and Z. The partnership itself is treated as a separate person from the partners which compose it. Okay, so the partnership in itself has its own rights and obligations, separate from the rights and obligations of each of its individual partners. Same as with corporations. Let's say McDonald's Corporation or the Coca-Cola Company. These are separate entities from their respective presidents, directors, or stockholders, meaning that in case of a partnership or a corporation, as the case may be, as juridical persons, they have rights to exist, to own, sell property, and other rights, subject of course to the limitations set by law, and they also have obligations, such as the duty to pay law, to observe labor laws, and other similar responsibilities. And if you would like to learn more about partnerships and corporations, I have complete lectures on each subject available here on this channel. And you may watch those for a deeper discussion. Just look for the playlist on partnerships or the playlist on corporations, and you can begin watching from there. Now, for today's discussion on liquidation, we will also be including a sole proprietorship, even though strictly speaking, a sole proprietorship is not a juridical person. Why? Because the law does not grant sole proprietorships a separate personality from the sole proprietor or owner. And therefore, a sole proprietorship enjoys less protection than the law grants to partnerships or corporations. Nevertheless, sole proprietorships will be included in today's discussion because they are expressly included under the coverage of FRIA. So when I mention juridical persons or juridical debtor in today's discussion, this will include partnerships, corporations, and sole proprietorships. Now, just like natural persons, juridical persons also go through the stages of birth and death. Okay? They are created and they also die. And it is the latter which is relevant to today's discussion. The end of the life of a juridical person is made up of two phases, namely dissolution and liquidation. Simply put, dissolution is simply the extinguishment of the life of the juridical person done either voluntarily or involuntarily, in which its existence, juridical personality, and business affairs are terminated. Okay, except for acts necessary to perform the second phase, which is the winding up or liquidation of affairs. Now, I won't discuss dissolution here because that's not the topic. And you can just watch my discussion on dissolution of partnerships or corporations if you want to learn more, no? But not today. You can just view it in the respective playlists of partnerships or corporations as the case may be, so that we can focus on the discussion for today, which is liquidation. And liquidation has been defined to be the winding up of affairs of the business entity by reducing its assets into money, settling with creditors and debtors, and apportioning the amount of profit and loss. It is the process by which all the assets of the corporation are converted into liquid assets or cash, and in order to facilitate the payment of obligations to creditors, and the remaining balance, if any, is to be distributed to the stockholders. It may therefore consist of adjusting the debts and claims by collecting all that is due to the juridical person, the settlement and adjustment of claims against it, and the payment of its just debts. Now, the normal procedure for liquidation is already contained within the respective laws for partnerships and corporations respectively, meaning the Civil Code for partnerships and the Revised Corporation Code for corporations, no? So, why does FRIA still provide us with rules on liquidation for juridical persons if they already have their own rules for liquidation under their own respective laws? That is because FRIA is a special law providing for the rules of liquidation for insolvent juridical debtors. So, if a juridical person is not necessarily insolvent and either voluntarily or involuntarily proceeds to dissolve and liquidate its affairs, then you can just follow the rules provided in their respective laws, such as Civil Code for the partnership or Corporation Code, Revised Corporation Code for corporations, as the case may be. However, if the juridical person is insolvent, then we follow FRIA. And how do we know if the juridical debtor is insolvent? Under FRIA, a debtor is insolvent if its financial condition is such that it is either generally unable to pay its liabilities as they fall due in the ordinary course of business, or if it has liabilities that are greater than its assets. Since we are talking about juridical persons, it is important to remember that FRIA does not apply to debtors that are banks, pre-need companies, insurance companies, or national and local government agencies, because the proceedings for liquidation are governed by their own respective special laws. So we don't apply FRIA here. Okay? Thus, specific to FRIA, liquidation refers to the proceedings where claims are filed and the assets of the insolvent debtor are disposed of and the proceeds divided among the creditors, and if any are remaining, then to the stockholders, proprietor, or the partners. And how is this done? Liquidation of juridical debtors may either be voluntary, meaning at the initiative of the insolvent debtor. It may be involuntary, as when initiated by the creditors of the debtor, or liquidation may come about as a result of conversion. It may be converted from a previously filed petition for rehabilitation. Now, voluntary liquidation, as the name implies, refers to proceedings initiated by the debtor. And this may be done in two ways. First, if there are ongoing rehabilitation proceedings, then the debtor can just file a verified motion to convert the rehabilitation proceedings into liquidation proceedings. Okay, he'll just ask the court to convert the proceedings. But if there are no ongoing rehabilitation proceedings, then the debtor can just apply for liquidation by filing a verified petition in the regional trial court having jurisdiction over the principal office of the debtor. This petition must establish the insolvency of the debtor and must attach several things, but I'll give you some important ones. Certificates attesting to the fact that the meeting of the directors was held and approved the filing of the petition. Another certificate attesting to the holding of a meeting by the stockholder, 2/3 of the stockholders or of the members as the case may be, approving the filing of the petition. Also, a schedule of debts and liabilities, a list of creditors and their respective claims, inventory of assets, receivables, and claims against third parties, and this is also important, names of at least 3 nominees to the position of liquidator, okay? Among other requirements which you can read in the law. Now, if the court finds the petition or motion, as the case may be, to be sufficient in form and substance, then the court will issue a liquidation order and the proceedings for liquidation can now commence. Okay? As for involuntary liquidation, proceedings may be initiated by 3 or more creditors, okay, 3 or more creditors of the debtor with an aggregate claim of either at least 1 million pesos or at least 25% of the subscribed capital stock or partners' contributions of the debtor, whichever is higher. Okay? So, similar to voluntary liquidation, the creditors may either file a verified motion for conversion of ongoing rehabilitation proceedings into liquidation proceedings. Or, if there are no rehabilitation proceedings, the petitioning creditors may simply file a verified petition praying for immediate liquidation of the debtor and in support thereof, showing that, first, there is no genuine issue of fact or law on the claims of the petitioners and that the due and demandable payments thereon have not been made for at least 180 days, or that the debtor has generally failed to meet its liabilities as they fall due, and there is no substantial likelihood that the debtor may be rehabilitated. So as you can see, that's one of the main distinctions between liquidation and rehabilitation. Remember, in our discussion in rehabilitation, there must be a showing of the substantial likelihood that the debtor can be rehabilitated. Here in liquidation, the debtor will be liquidated because there is no substantial likelihood that it can be saved or rehabilitated. Now, this petition filed by the creditors must be accompanied by a bond in an amount equal to the aggregate of their claims, conditioned on paying the debtor all expenses and damages which it may suffer by the filing of the petition in case it is dismissed or withdrawn. Okay? The petitioning creditors must also allege, to the best of their knowledge at least, the assets, liabilities, receivables, and audited financial statements of the debtor. Now, if the court finds the petition or motion, as the case may be, to be sufficient in form and substance, then the court will direct publication of the petition or motion in a newspaper of general circulation once a week for 2 consecutive weeks. And the court will have to give an opportunity to be heard by directing the debtor and all creditors who are not petitioners to file their comment. Okay, that's the opportunity to be heard by writing it in the comment. Okay, which must be filed within 15 days from the date of the last publication. Okay, and after resolving the comments, or if there are no comments, then the court can now issue the liquidation order and the liquidation proceedings may now commence. So, it's clear that not only can petitions for liquidation be filed either by the debtor or its creditors, liquidation may also be initiated as a result of conversion from previously filed rehabilitation proceedings. And lucky you, for the sake of your convenience, the following are the cases under FRIA where rehabilitation proceedings may be converted into liquidation proceedings. First, we have Section 25, under which within 10 days from receipt of the report of the rehabilitation receiver, the court may convert rehabilitation proceedings into liquidation if there is a finding that the debtor is insolvent and there is no substantial likelihood for the debtor to be successfully rehabilitated. Second, the court may also order conversion of rehabilitation to liquidation in case of objections to the rehabilitation plan which are not curable, or in case the debtor acted in bad faith. And this is under Section 67 in relation to Section 66 of FRIA. Third, rehabilitation may also be converted to liquidation proceedings either upon motion or at the court's own initiative motu proprio if the court does not confirm the rehabilitation plan within the period of 1 year from the filing of a petition to confirm the rehabilitation plan, as provided under Section 72 of FRIA. Fourth, in case of failure or rehabilitation or dismissal of the petition under Section 75 in relation to Section 74, the proceedings may also be converted into liquidation. So aside from dismissal of the petition, other examples of failure of rehabilitation include failure of the debtor to submit a rehabilitation plan, or the rehabilitation plan shows that there is no substantial likelihood that the debtor can be rehabilitated within a reasonable period, or fraud in securing the approval for the rehabilitation plan or its amendments, and other analogous circumstances. The fifth situation of conversion is in case the debtor or the creditors have acted in bad faith in supporting the rehabilitation plan as provided under Section 80 of FRIA. And last is what I have already mentioned earlier, through the filing of the appropriate motion by either the debtor or the creditor as the case may be under Sections 90 and 91 respectively of FRIA. Now, as I mentioned earlier, I won't be going into detail about procedural matters such as the full list of contents and effects of the liquidation order, or the election, removal, qualifications, powers, and duties of the liquidator, and the rest of the proceedings after the issuance of the liquidation order. Okay? These things you can either read on your own if you're a student, or in case you are the insolvent juridical debtor, it is best to leave it up to your lawyer instead. No? But nevertheless, I will still give you a brief overview of the proceedings after issuance of the liquidation order, starting with some important matters about the liquidation order. Now, this liquidation order is important because it declares the debtor insolvent, it sets the case for hearing for the election and appointment of the liquidator, and orders the liquidation of the debtor by vesting legal title and control over the assets of the debtor into the liquidator, and directing the payment of claims due to the debtor to the liquidator, directing creditors to file their claims with the liquidator, and prohibiting the debtor from making payments or transfer its property, among others. Note, however, that this liquidation order will not affect the right of a secured creditor to enforce his lien unless he waives his right in writing prior to the election of the liquidator. As for a brief overview of the proceedings, they are roughly the same as those for liquidation of individual debtors, which I discussed in the previous episode, but with minor changes, especially in the stage of termination of proceedings. So, after the issuance of the liquidation order, the creditors will now file their claims with the liquidator, who will then submit a liquidation plan to the court for approval. The liquidation plan will enumerate the assets of the debtor, and it will also that are not exempt from execution, and also a list of all the creditors and their proven claims, as well as a proposed mode and schedule of liquidation of assets and payment of claims. After the court approves the liquidation plan, it will now be implemented, ensuring of course that the rules on concurrence and preference of credit under Philippine laws are observed, unless of course a preferred creditor voluntarily waives his preferred right. With the approval of the court, the liquidator may sell, transfer, or otherwise dispose of the unencumbered assets of the debtor to convert them into money. And as a general rule, the sale must be at a public auction. Although the court may approve a private sale if the goods are perishable, if it is disproportionately expensive to maintain, or if it is for the best interest of the debtor and its creditors. The court may also allow specific property of the debtor to be conveyed to a creditor in payment of whole or part of the creditor's claim. After the sale, the proceeds will now be distributed to the creditors in accordance with the liquidation plan. Thereafter, the liquidator will submit his final report and accounting to the court, which, if satisfied, can now discharge the liquidator, and the court can now issue an order approving the final report and directing removal of the name of the juridical debtor from the register of legal entities of the SEC and other government agencies as may be applicable. Once the court has received evidence from the SEC that it has removed the juridical debtor from the registry of legal entities, then the court can now issue an order terminating the proceedings. Okay, so take note that this is only a general overview of how the proceedings may go. So there are definitely some omissions which you can either leave up to your lawyer if you are the debtor, or for you to study if you are a student. So that's it for liquidation of insolvent juridical debtors. To review, liquidation of partnerships, corporations, or sole proprietorships may be initiated voluntarily by the debtor itself or involuntarily by the debtor's creditors, or converted from previously initiated rehabilitation proceedings. The ultimate aim of liquidation proceedings would be to settle the affairs of the debtor by accounting for all its property before disposing of or transferring the same to satisfy the claims of its creditors, and if any still remains, for distribution to the stockholders, members, partners, or proprietor as the case may be. So, I hope you may have learned a thing or two, and I hope to see you next time. See you soon, guys. Bye.